Leave the ICO.
Welcome to the Information Commissioner's Office. If you want to use our Welsh language service, please press 9. If not, please hold. We don't audio record calls to this helpline. For information about what we do with personal data, please visit our website at ico.org.uk/privacy-notice. Our helpline is for organisations, people who work for themselves, and for members of the public. Please note, we will treat all people with courtesy and respect, and we expect the same. If anyone behaves in an unreasonable way to our staff, we will bring the call to a close. To help get you through to the right team, please select from the following 3 options. If you know the extension number of the person you want to speak to, please press 1. If you're calling from an organisation, a small club or association, you're a sole trader, or you work for yourself, please press 2. If you're a member of the public, please press 3.
Number 3.
Here are your 3 options. To discuss an inquiry or complaint you've already sent to us, please press 1. To discuss a new inquiry or complaint with us, please press 2.
2.
If you're a whistleblower, we're now transferring you to a member of our team. Information Commissioner's Office.
Yes, good afternoon. Can I ask who I'm speaking to?
I'm Ben, I'm one of the advisors here.
Your name is Ben?
Ben.
Ben, hi Ben. I'm a member of the public and I'm making some general inquiries for general information regarding what constitutes a data breach. Is that something that you can help me with?
I can talk through the scenario and provide you with a view on whether a data breach has occurred.
Yeah.
So
Okay.
what happened?
So basically, it's regarding a housing association of which one of my family members is a tenant, and as you can appreciate, we live in social accommodation, and the housing association tenancy required a considerable amount of personal information regarding the tenant's circumstances and also those individuals that would be residing in the at the property. So that's, I think that's just standard procedure. What I'm trying to highlight is that it's just not a one-to-one relationship where you have one tenant and one landlord and the information is restricted to the particular tenant. The landlord on this occasion has requested substantial information regarding all those extra people that would be residing at the property. So my information has been handed over, and several other family members' information has been handed over, and that's fine, as long as the data is protected. And this was like a number of years ago, maybe let's say over a decade ago. I've then subsequently proceeded to make a subject access request for full disclosure of said records under the Data Protection Act. And the housing association begrudgingly have complied with the release of that data. I subsequently raised an issue that not all the information has been disclosed, and they said that we need further authority regarding the other individuals because they started redacting it, and so they then proceeded to make a second disclosure, and that was fine as well. And there's not an issue with that. I did raise an issue with the housing association that I feel that there are documentations that were provided that have not been disclosed, but they were quite adamant that there was no further information, that they've complied to their obligations to the subject access request. And I thought, well, that's fair enough. Several years have passed, and subsequently the housing association has now proceeded to take litigation action against myself. And so therefore, as part of taking the litigation action, under a different piece of legislation, namely the civil procedure rules, I've asked them to make full disclosure of the housing file, file. What I found is that upon them, so they have complied with that as well. So they've complied and made a fuller subject access, fuller disclosure, but under a different set of
under CPR,
under different rules. But having compared and contrasted what I've now received, it seems evident to me that they had, suppressed or withheld information, relevant, historic documentation in the first two subject access requests. So now I have evidence that, my concerns originally raised that there were extra information that you're not providing me with, have now been substantiated through this reason. So I just wanted to get some information regarding this, that, under a subject access request, if it's not been fully complied with, and then later it emerges that there was evidentially emerges that certain information was withheld, where do I stand in relation to the Data Protection Act on this?
Well, the main thing, technically it's a breach if you could evidence that directly.
Okay.
But what you would achieve with that would be you'd have a right to apply for compensation for damages caused by the not having been given it all the way through. What does happen quite often is that organisations find different information when they look at the same request several years apart. And I've had situations where either there's been more information on file, or they've had a different view about exemptions, particularly if we're going back several years. And they may well, a data protection officer may well have had a different view as to what needed to be redacted from the file, and may have been redacting whole documents rather than partial documents at one point. Trying to look at what, and if short of trying to sort of prove that you were caused damages as a result of not being given them, and that it kind of intends not to. It's kind of, you end up with, yes, we can prove now that you didn't get all the data 4 years ago, but how's that caused? How it's looking at considering how's that caused detriment?
Oh, okay.
As a regulator, there's not a lot we can do about how the organisation dealt with it 4 years ago. It's much more how they're dealing with it now.
Yes, I understand. No, I'm not trying to, bring a case to yourself. I'm just asking, technically.
Technically, 4 years ago, they should have provided you with the information they had at that time. What gets difficult is trying to prove what information they could locate at the time they were looking.
Yes.
And also, even they possibly won't have records of what they found at that point compared to what they chose to provide.
Yes, I understand.
It's quite common in employment tribunals for the individual to make an access request to the employer around the point where they were ending the employment. And then they get to the employment tribunal, and then they go through CPR at the tribunal, and they get a whole different set of information because the lawyers preparing for the tribunal have spent hours and hours and hours putting together extra information that they didn't have on file in one place at the first point when the person first left, that they managed to compile together. But beyond making the representation to the tribunal that, well, I should have got all of this in response to my SAR months ago, there's not that much can be in sort of.
No, I understand.
It's now available to the tribunal, and we're into nothing has changed particularly.
That's fine. Thank you for that clarity. And point to the consequences to one side, or what beneficial interest or what advantage do I have. I'm just trying to establish the fact that I had made subject access requests. Now, as you can appreciate, several years later, obviously more information is going to be available, but it's going to be post the previous SAR request. So you understand that? Yeah, I understand that. Now, because I made information, through a different means, there's going to be further information subsequently, which has now been disclosed. But the point that I was trying to raise is that, and also you're right. If on the original SAR request that had been heavily redacted, and now they're not redacted, that's also understandable. But where there is been documentation that, like for example, in this housing association, relevant documents were provided at the start of the tenancy. So, for example, personal information regarding financial circumstances and stuff. So that is the foundational basis upon which the relationship exists. And so you would expect that those documents, which were central to the tenancy agreement, would have been disclosed. And if they've not been disclosed through the SAR request and then subsequently have been disclosed, and we're not talking about redactions here, we're talking about wholesale documents not being provided. And when inquiries have been made, well, wait on a minute, these documents should have been provided because I remember giving you these documents and refuting them. And then subsequently now realizing that these documents were available. I just wanted to ask, like on a technical basis, that is an argument to be made that these should have been provided, and at least a justification for why were they not provided. I mean, if it's a decision that we felt that they need to be withheld, then that's fair enough. But for them to say, no, we don't have these documents, when the SAR requests were dealt with, this is all we have, and then subsequently finding out, well, actually, you did have these documents, and you didn't just make them available to us. And I just want to know the justification of why they've been held. If it's just a genuine mistake, that's understandable. You know, we all make mistakes, but what I'm trying to establish is there was an element of malevolence, or intent, bad intent. That's what I'm trying to establish. If there was bad intent, that's all. That's what I'm trying to establish. So that's the first point, and I think you're in agreement with me that if there were documents available that are now that are now being presented to me, they should have been presented at the SAR request.
There's an argument for that.
Okay.
And certainly, you can put the complaint to them that this wasn't provided to you in response to the access request that you submitted.
Okay. That's fine.
Whether they chose not to provide you with particular documents at that point, there are exemptions to do with where the person's already got a copy of the information, but it's kind of it. But particularly where you're several years after the access request, they may not know how they considered the request at the time, because most organisations, it's sort of 6 to 12 months after they deal with an access request. Why do they need to keep a copy of their decision making from that request?
I understand. Okay.
I
remember
talking to a big organisation once, and they've been trying to keep stuff for 12 months after an access request in case there was a complaint, and they were literally running out of warehouse space, and then it's like, you really don't need to keep it that long.
Yeah.
It's kind of, yes, okay, there might be the odd one you have to redo because the person loses all the bundle, but keeping a record of how much do you actually need to keep a record of what the logic behind what you chose to put through. And I've often looked at access requests over time, and it's quite commonly the case that you look at a file and think, well, I might not have done that one, but I would have done that one. And kind of at each data protection officer would have a slightly different approach to how they redact or how much they redact. There's no there is no prescribed absolute standard. We're all similar, but data protection exemptions are very blurry.
Yes.
They're not. The Freedom of Information Act, you can pretty much guarantee that most people responding to the request would reach a very similar conclusion. But with data protection, there's quite a lot of room for the request to be different. And the big one I find that is trying to look back at kind of what information you could find at the time versus what you could find at a later point. And I see cases where the organisations respond to say, no, we're between contractors with our CCTV, we haven't got access to the footage at the minute. And then 12 months later, there is, the person saying, but it turns out you've got the footage now, we're in court. It's like, yeah, because 12 months later we've sorted out the problems with CCTV suppliers, and we have got access to the footage that was historical.
Yes, I understand.
But it doesn't mean that they had access at the time when they declined the request, saying, no, we can't access it at this point because we're between contractors.
Yes, I understand. I mean, I understand there's a broad discretion to the data controller. I understand that. And obviously, like I said, these what you're describing are genuine, circumstances where somebody's, it's all to do with intent, and if their intentions are honourable, but however there are difficulties, I think everybody would agree that that's permittable. It's only when there's malevolent intent, obviously that's more difficult to prove or having to deal with when somebody's like acting with malevolence. But you're moving on from this, so that's the first point that I wanted to discuss with you. and you've provided me with that information. So moving on from this, so the next thing is that, when I made these subject access requests, I had, the organization, the housing association, were, quite adamant that, this is, privileged information, and we want to ensure that it's secured and stuff. And I had at the time requested that, look, I would like you to upload it to my cloud server, which is secure. And they had this whole procedure where they were, quite conscientious of the data not going into the wrong hands, which obviously I felt very comfortable with. So the organization had proceeded to, meet my expectations of ensuring that once a subject access request has been made and going to be facilitated, that the delivery of that information is secure. And I was very satisfied with the SAR request delivery being secure. So I didn't have an issue with that. Now, subsequently, what's happened is that when I've made this request to the, obviously because the litigation proceedings have started, I've made this request to the solicitor saying, look, under, CPR rules, I'm, requesting disclosure. Now, my, full disclosure of the tenancy or housing file. Now, my expectations were that that level of security would still be maintained, namely that they would look to ensure. So this is now no longer the housing association. This is the solicitors firm who I'm now liaising with. And what they've proceeded to do is send the housing file via email, unsecured, not password protected. And that I have certain concerns and issues with, because originally there had been, under the data protection act provisions made that, there would be no interference. It was on a secure server. The files had been password protected. But simply for me making a disclosure request now from the solicitors, they've just proceeded to send me the file as email attachments, not password protected. Now that's concerning to me, because that's not just my data in there, but my whole family's data, passport record.
Yeah.
So I just wanted to ask.
It's worth making representations to them that you feel they ought to be using some form of encryption, even if it's just applying a zip file and providing you with a password separately so that you could access stuff. But if you just, and so I'd certainly be reporting to the lawyers concerns about use of insecure email. I'd be tempted to raise it with their data protection officer at the firm as well. For just sending insecure emails. If you went to the legal firm's website, they should have a privacy policy, and that should give you contact details for the data protection officer to raise a complaint about sending out documentation that really, surely it's not that hard to put a password on the doc file.
Yeah.
Or to,
I mean, what?
Pop it inside a WinZip folder.
Yes, or something like this. I mean, the concern I have now is, as you can appreciate, that housing association's primary modus of operation is to be a landlord. All right, this the aspects of and so therefore, that's their main operation. Whereas obviously they have obligations to the law, namely the Data Protection Act, to deal with all this administrative side. What concerns me is regarding the solicitors firm, which, as you can appreciate, they're not my solicitors. They are the housing association solicitors, and their bread and butter effectively is documentation, sending files, and if this organization on this particular occasion with myself have chosen to send files to me as a zip file, it just shows me that this particular solicitors firm are not this may be like an everyday occurrence with them, because obviously they don't seem to have realized. I mean, can you understand? It is more reasonable to be forgiving of the housing association because this is not something that they specialize in. Or
there is an argument they should have better.
Yeah.
It's making clear that, at least in your case, they need to be aware of their obligations, and you're very surprised they're not.
Okay, and so that's the first point. And the second point is that obviously I've contacted them back and said, look, well, I didn't anticipate for you to be sending them by email. I want a hard copy of the housing record. And I've asked them to send it like a recorded delivery or something, to just so it's secure. Now they've proceeded to send it through the postal system, through first class mail or something, and it's gone missing now. So I just wanted to know, these are once.
Post is fairly as means of transferring information. The post itself is not particularly inherently secure because there's a whole bunch of criminal offences around the way the post office handle information. It's only potentially receivable by one individual if it's a direct delivery to an and there's even criminal offences if that person who then receives it uses it for anything other than returning it to the sender or forwarding it on to the person that should have got it. And the difference, the post office don't do anything substantially different with recorded delivery posts compared to regular post beyond asking for a signature at the other end so you can see whether or not it's been received. But what happens in between points, it's a very similar process. So the postal, whereas with email, there is lots of room for third parties to see the information.
In fact,
and that's why the use of encryption folders or passwords on where you've got documents is a reasonable practice and reasonable expectation. Well, you have to produce guidance talking through that.
I mean, I understand that. I mean, obviously, through the post, it is a level of security. That's hence why I asked for it to be sent via the post rather than email. And with regards to email, it just bounces around on a server. Each one of those servers has an exact copy. So hence why it's called unsecure, because every time you send an email, as it bounces through the network, each one of those network nodes gets a copy of it. Because it's not encrypted. So I just feel that is a far more of a serious data breach where they send it by email unsecure. Well, how we send it, the other scenario is where they send it through hard copy through the post. Now it has gone missing in my particular circumstances, and I've informed them of this, and they've then proceeded to send it, signed for. But can you see there's a pattern emerging here where it seems that this solicitor's firm, which obviously I have not constructed, I seem to be doing things in a very haphazard way, where they deal with legal case files. Why would it not be a standard practice on this law firm to send all case file documents or disclosure documents through a level of security where they can evidence that it's been signed for? Now, because I've not received the first bundle, I've gone back to them and they've sent a second bundle. And so I just wanted to know what, can you understand that how I have concerns now? This is a potential bundle that, it's out there and I have not received it.
First step in that's going to be raising the complaint with the data protection officer, as I indicated before. You kind of make representations to them that they're not using an appropriately secure method of sending the information out, and it's kind of to raise it with them as a complaint. If you get a shoddy response from the law firm's data protection officer, you can make a complaint to us.
Okay, all right.
But it's kind of, the first step's going to be raising a complaint with the data protection officer of the law firm itself.
Okay, all right, that's fair enough. I mean, and just the one final point, sir. And the final point is that I've asked for the information that the solicitor provided to be paginated and indexed, which would obviously require them to go through each A4 letter piecemeal. Obviously, once again, the approach taken by the solicitor's firm is now, we're not going to do that. It's going to cost us too much time and stuff. So we're just all going to bundle it all up into a big folder and just send it to you. And so they've proceeded to do that, and they've just proceeded to send me the whole case file in a very jumbled, disordered manner. Now that's their option. That's what they've done. But while I'm going through the bundle, I've discovered documents that should not be in the case, like relating to somebody completely independent, different, who I should not know about.
So you need to submit. I'd suggest forwarding images of those documents to the data protection officer of the organisation and explain that you've received them. This is a data breach. They need to be reporting it internally as well as to their clients, considering if they need to report it to the data protection regulator, and then also considering how they're going to secure the retrieval of these documents from you.
Oh, okay. So, but under that is a clear data breach. Then, if I'm now in possession.
You shouldn't be receiving other people's documentation. Yeah.
Yeah, so that is those are the several points I wanted to discuss with you because it just seems a very shoddy means of operating, and I feel aggrieved because, as you can appreciate, this solicitors firm charge a solicitor's fee, and their clients would inevitably look to pay them a solicitor's fee, which inevitably if they are successful in their litigation, was a cost that I'm going to have to pay to a solicitor's firm that I have no control over, and that I feel aggrieved at that this is what they should be doing, and it's not
Yeah,
my.
those are arguments you can obviously make at the point of
Yeah.
any subsequent
Yeah.
court hearing, considering costs
Yeah.
involved.
Yeah. I
But,
understand.
but the initial thing is going to be, I'd obviously keep a copy of the emails you send raising the issue, but I think you need to be reporting the data breach to the firm and following their instructions over what they tell you to do with the information. So if they tell you to delete it, then you delete it. If they tell you to return it to them and provide a guarantee, and
No,
stuff, then
but what reprisal actions do they suffer from for being lackadaisical and haphazard? And obviously, I've explained to them that this is what they should be doing, namely that they should be sending it through a hard copy, through secured.
but the main thing is that they're liable for damages caused as a result of their own errors. If depending on what happens next, you can make a complaint to us, but I'm not sure this kind of case would end up being a punitive monetary penalty situation.
But I mean, with
You're
regard,
welcome to make a complaint to us.
yeah, no,
But the main way designed in the law is that they're liable for damages caused as a result of the error. So they need to be looking particularly, and probably the biggest risk to the firm is particularly when they start going back to their clients saying, "Oh, you gave us some documents the other week. We've mixed it up in a bundle and sent it out to totally the wrong person. But we need to report this to you because we've had a data breach and it's part of as it's your information as our client, as your data breach." They might not be surprised when they find out that their client is not renewing their contract, which is a detriment.
Okay.
But that's why. But you need to be reporting this.
Yes, but and I will inevitably look to do so. I'll make them aware of my inquiries. But can you understand? This is somebody. I'm not here to be somebody's teacher, or here to rectify other people's problems. And I just feel aggrieved at the fact that this is my time and resources that I'm having to give up, and the net outcome is that no damages. I mean, with regards to the emails, that I can make an argument that that's been my damage caused to me. But being in possession of somebody else's data is not damage to me, but it is damage to the potential person whose data I've now obtained.
Yeah, and it's once you've reported it as a data breach, they need to consider whether or not they need to inform the individuals affected, because that's what, as I was saying, is once you've reported it to the legal firm, they're going to be obliged both to record it internally and to report it to their client,
Mm-hmm.
and then and their client is not going to be impressed to find out that their information is being sent out by their lawyers to completely unrelated cases in the folder, and the firm isn't going to, as I said before, the firm's not going to be surprised if they find out their contract's not being renewed or they're no longer the employers employed to represent that individual, and that's kind of what I haven't got much else I can cover on the phone today, really.
That's fine. I mean, but
and yes, the client could reasonably make a complaint to us. If there is major information involved and the firm has a list of problems, then it may end up being that the firm gets a monetary penalty and is going to begin to undermine any claims for costs in your case, that the firm is this shoddy that it ends up.
Yes. I mean, under these, just for clarity, under these.
That's arguments I really think it's kind of it's something you need to submit and argue to the data protection officer of the law firm.
Yeah, no, that's fine, and I will be proceeding to do so. But I just wanted to clarify that the documentation, the data breach, has not been caused by the solicitor giving other people's the solicitor's clients information. It's the housing association's tenants' records that it's another tenant, the data that has come to me via the
Yeah,
solicitors.
So
So
it's for the solicitors to look at why that was left in the bundles, and
yeah.
if it is that their client has been shoddy with the looking after the information, they're going to have to both go back to their client and say, well, we've just done a data breach because you haven't looked after your records properly, and kind of it's the housing association needs to consider how it's looking after the information if it's managing to have information on the wrong file. But it's important. That's why you need to go back to them.
Okay.
If afterwards you can make a complaint to us, but the first step is going to be making a complaint to the housing association and their lawyers about how they're handling the information and them providing you with other people's information.
Okay, all right.
So contact details for the data protection officer for the housing association will be on there.
Yeah, I understand.
Their privacy policy on their website, as is the
okay. Yeah, no, that's what we'll be proceeding to do. But you know, if I obviously if I'm taking the time, effort, and resources to highlight the housing association or the solicitors firm's failures to them, which I will be proceeding to do, what rights are afforded to me to know the fact that they are accountable to me to show that they have rectified their procedures and policies? Because obviously the whole point of me saying to them, look, you really messed up here, and they're saying, all right, thank you, we'll deal with it, and not,
They haven't got any specific obligation to set out to you how they update their policies. Their obligations are much more to do with updating their policies rather than. But if you feel their responses aren't taking it seriously or aren't, then you're welcome to make a complaint to the ICO about how they handled it and that you don't believe they've learned anything from the errors they've already made. But before you do that, you need to raise it with them directly so they have the opportunity to consider and review their processes.
Okay, but but they're not obligated to. They're not obligated to update me as the complainant.
No.
Yeah. I just really question my own justification and motivation to raise a complaint where there's no net benefit for me personally. Where as of raising the complaint, there's a clear net benefit to a business organization that should be complying to the law and have failure to do so. Can you understand my position?
I understand your argument. I just haven't got anything more I can advise.
Yeah, that's fine.
Raise it with them if you don't wish to. It's just that really you should be because you've received someone else's data.
Yeah.
So you I'd probably argue at this point you have an obligation.
Okay.
I've recommended quite a few times already that you raise it with them.
I will do.
Much more I can recommend at this point.
That's fine.
You can obviously leverage that within your argument at the tribunal when you find yourself in court.
Yeah.
And you get, as I'd expect you would do.
Yes.
This is a terrible organisation. They had other people's data all over your files. They've employed the shoddiest lawyers going and can't be bothered to even apply encryption to documentation when they send it out, and they're happy to send bundles to wrong addresses or lose it in the post.
Yeah.
And it's kind of that. That's all stuff you're going to be raising in court, and it's going to undermine their case.
Yes. I mean,
I haven't really got anything else I can advise on the phone today.
No, that's fine. You've been very, very helpful and assisting. Just one last point is that you said, if a data breach has occurred, i.e., in this instance, I have received somebody else's documents through no fault of my own, through somebody else's fault, and you said I am obliged. Can you please clarify and elaborate on where that obligation arises from?
So there's provisions in data protection around this sort of an offence if you've received information that isn't yours, it still remains controlled by the organisation, and you need to follow that organisation's instructions. So if you start using this information for your own purposes, if you stuck it on your own YouTube channel, then you might well find that there is because this information still falls under the data control. It's not information that should have been provided to you, so it falls under the data controllership of the organisation.
Okay.
You can't just kind of arbitrarily just pop it on your Instagram and say, "Oh, look what they've sent me."
Yeah.
Because this is information that's under the data control of the housing association and their law firm, and these kind of you could end up finding yourself committing an offence or something if you start using that for your own purposes rather than informing the organisation that you've received it and following their instructions. If you were told we're writing to you to say you must destroy this information securely or return it to us by return of post here's an envelope to return it to us. If you refuse to do that, there is actually a criminal offence you can commit, because there's
What is
no
the
point of backing it.
what?
Because when you are instructed to return documents to them that you shouldn't have received, you have to follow that instruction.
What is a criminal offence?
As part of the sections of Data Protection Act.
Okay, so part of the Data Protection Act section is a criminal offence rather than a civil issue.
Yeah, there are criminal offences in data protection.
Okay, that's fair enough.
Amongst those include if you take information from an organisation that you're not supposed to have and do stuff with it that you.
Yes, I mean.
And it includes where you've received information in error from an organisation and don't follow their instructions of destroying it or returning it when instructed to do so. But
they would only become aware of the need to destroy the data upon my informing them. All right.
I think you'd still be processing it. If you start using it for your own purposes, then there is an offence that you would affect.
Okay, all right. Okay, all right. That's fair. That's fair.
I really haven't got much. I've advised you, you do need to report if you receive these documents to the Data Protection Officer.
Okay, all right.
I've said that a few times.
Yes, and have I objected to that? I will be, and I've agreed with you that I will be doing that. That's not a problem. We've
covered the same point a few times.
Yeah, no, that's fair enough. I mean, just one last point. You just touched on the fact that if I record it and put it on my YouTube, that just reminds me. This call is not being recorded by you, is it? No, this call is being recorded by me as a policy. Okay. Just to let you know, and I'm not obliged to inform you as a private citizen that I'm recording this call, am I?
I know.
Yep.
No, you're not.
No, all right. So just as a courtesy, I'm just going to be making you aware that I'm going to be passing on this advice and the recording to the data protection officers in this case. Would that be a concern to you or?
Not a concern to me to share it with the data protection officers.
No, that's all. That's all.
They were calling.
It's just
business advice for that as well.
Yeah, so it's just basically I've taken my time to get this advice. I just want to get this advice to them that I've rang up the Information Commissioner's office. This is this is directly from them. You can listen to my conversation, the concerns I've had. It just basically saves me time from repeating and putting things in writing where they can just listen into this call. I just want to know that you don't have a personal issue with this. That's what I'll be proceeding to do.
I don't have any problem with you putting I've said already I don't have a problem with you providing a copy of the recording to them.
Yeah, that's right. Okay, well, thank you very much. Thank you very much for your advice and assistance today. It's been very helpful and informative. Have a nice day, sir.
Okay. All the best. You have a good Friday. Stay safe.
Bye-bye.